Good morning, everybody, and welcome to everybody that's tuned in to today's webinar. My name is David King, and I am a partner at Harrison Clark Rickaby's. I'm part of the firm's Wills, Trusts and Estates team. I'm going to be chairing the discussions today, during which we are going to consider how you can protect yourself and your loved ones during the current climate, take a brief look at employee benefits and the security of cash assets held with banks, and also to look at lasting powers of attorney, LPAs, and end-of-life planning. I think it's just worthwhile me pointing out that what we're going to be discussing today is relevant during the COVID-19 crisis, albeit tinged perhaps with a slightly heightened sense of importance and time sensitivity, but will remain just as relevant and important when this is all over, which is hopefully sooner rather than later. I'm going to be joined on the panel today by John Solosy of Solosy Wealth Management. John's going to be covering a number of topics to include employee benefits, looking at beneficiary nominations. He's going to be looking at cash holdings and security with banks, and also some IHT inheritance tax planning measures. I'm also joined by Emma Saysell, who's the CEO of St David's Hospice Care. Emma is going to be looking at DNRs and some advanced care planning for people with capacity. Emma's also going to draw on some real life experience of how the staff support patients and relatives in the hospice coping with bereavement. And finally, but by no means least, Annabelle Kay, who is a colleague and a senior associate at Harrison Clark Rickaby's, is going to look at lasting powers of attorney, discretionary trusts and life interest trusts, with a particular focus on looking at vulnerable beneficiaries. The seminar has been scheduled for 60 minutes, but to ensure that the panelists are in a position to answer as many questions as possible from our attendees, we're going to aim to speak for sort of around 20 to 30 minutes, allowing plenty of time for questions at the end. Hopefully everybody can see the Q&A box, which is at the bottom of the screen. Please feel free to pop questions into the box at any time, and we'll look to deal with those at the end, or if appropriate, I will ask the speakers to deal with questions as and when they arise, if possible. In terms of any questions that are placed into the Q&A box, I will keep them anonymous, just for everybody's sake, really. So let me start things off by looking at the importance of wills. So Amelia, if I can ask you to flip to the next slide for me, please. Thank you. So I find it really odd when I meet with clients that they apologise for the makeup of their estate. Now, I think it's probably a natural human reaction, but when we're looking at assisting clients with drafting their wills, the size of the person's estate is irrelevant to me, really. Yes, there are some inheritance tax planning measures that we can look at and discuss with them. But for me, in terms of when you are putting a will in place, it's all about leaving your own legacy. Now, in England and Wales, we all have what we call complete testamentary freedom as to how we deal with our assets that we own on death. And essentially what that means is that there is no fixed succession laws that apply in England and Wales. And that means that you can effectively leave your estate to anybody you like, and in any proportion that you deem is appropriate. Now, what I want to draw on this morning is some personal experience that I've had myself recently of updating my own will, when I sort of reversed the role of me normally taking instructions to giving them to myself, it was interesting to sort of see the responses and the thoughts that came into my head when I was asking those what-if questions to myself. Now, the key drivers for me when I was thinking about my own will was how I can protect my young family financially, but also, and I think perhaps most importantly for me, was if both me and my wife were to pass away, who would be appointed as guardian for my young son. Now, dealing with this guardianship point first, I think this is probably one of the most important decisions that any parent or individual that has parental responsibility for a child can make. And I think I would urge anybody listening to this that is in that position, if you haven't made a will, or the will needs to be updated to include guardians, that it's something that you should strongly consider doing. Now, with the best will and intention in the world, sitting down with close family, friends that you've chosen to appoint as guardian for your children, and sort of explaining to them what you would want to happen in the event of your passing is not something that happens over the Sunday dinner table very often. And whilst the will allows you to choose who you want to act as guardian, it doesn't very often tell the guardians how you would want them to act. So what what can be done to address that? One of the things that I strongly advise clients to do is to consider putting in place a letter of wishes. Now, the purpose of the letter of wishes is to accompany the will. It doesn't form part of it, and the letter of wishes itself isn't legally binding on your guardians, but what it does act as is a point of reference for them. So no doubt, if you've got children, you'll all have strong wishes for them, perhaps in terms of what religious upbringing they have, things like where you would want them to go to school, and what experiences you would want them to have growing up. And these are all things that your guardians may not know or understand in as much detail as you would want them to. So putting in place those side letters of wishes to go with the will can often really help and act as that point of reference. So the second thing that I was considering is how I can protect assets for my chosen beneficiaries, and in terms of leaving my legacy. And I know John is going to touch on later the issue of mortgage protection and life insurance, and those are really important. But what I would just stress, and I know John is going to mention this later as well, is just make sure that your beneficiary nominations on those policies are up to date. Now, when it comes to the actual structure of your will, it's not just who you want to benefit, but potentially who you don't want to benefit. And the benefit of having complete testamentary freedom in the UK is that it is entirely your choice as to who you wish to include in your will, and also who you don't. Now, when we're taking instructions from clients for drafting their wills, one of the things that clients must consider is if there is anybody that may have a potential claim against their estate on death. Now, if you were to look at a situation whereby I would pass away, and following my death, my wife were to remarry or cohabit with somebody else, not that I don't want her to be happy following my death, this could lead to a situation where my wife changes her will and potentially leaves assets to individuals that I wouldn't have wanted to benefit at a point in time in the future. So what options would be available to me to try and protect the assets that I'm leaving behind for beneficiaries of my choice? So one of the first things that we would always consider with clients is whether they want to incorporate what's called a life interest trust into their wills. So what is a life interest trust? This is effectively a provision that's set out in the will that gives a beneficiary or beneficiaries of your choosing a right to receive an income during their lifetime following your death. Now, if I take a scenario whereby I've left my property into a life interest trust, what that would do is it would give the beneficiaries of my choice a right to live in the property for the rest of their lifetime, potentially. Now, as to when the trust comes to an end, it could be on the chosen beneficiary's death, but it could also be at an earlier event. So if I wanted to say that I wanted that right to live in the property to come to an end in the event that the beneficiary were to remarry or cohabit with somebody else, I could do that. And the benefit of that is that it then means that following the trust coming to an end, the asset, the property that I've left into the trust following my death would then go to the beneficiaries of my choice as dictated by my will, and not by the will of, in this case, my wife at a point in time in the future. So this is just one area in which we can help assist clients with what I would phrase generational planning. So allowing for my wife to have a roof over her head for the rest of her days, but ultimately protecting the capital value of the property for my children. There are other options, such as the inclusion of discretionary trusts in wills. So what's a discretionary trust, and contrast that with a life interest trust? So under a discretionary trust, no one beneficiary that's named in the will has an absolute right to benefit, and it is completely at the discretion of the trustees as to who benefits and at what point in time and to what extent. Now, there's a great deal of flexibility built into these wills, but they have benefits that Annabelle's going to touch on later, potentially for vulnerable beneficiaries. But also, I know 18-year-old me would be rubbing his hands together at the thought of receiving an inheritance at the age of 18. But you know, if I were in a position where it wasn't appropriate for me to inherit due to personal circumstances such as going through marital breakdown or other financial circumstances that mean me receiving assets from an inheritance would have an effect, then lots of people like the idea of being able to build in that flexibility to their wills to allow the inheritance to be deferred until a later stage. Now, there are tax consequences associated with building in discretionary trusts and life interest trusts into wills, and I think I could talk for hours on end about what those are. But what I would say is, one of the reasons why I really enjoy the work that I do is because of the fact that no one person's estate is the same as another, and there are many reasons as to why people decide to leave their estate in a certain way, and that's one of the reasons why I strongly advise that individuals must take appropriate legal advice when looking at drafting your wills. The initial drafting of the will is only the start, and what I advise all of my clients to do is to revisit the content of the will at least every 2 years. That's not to say that the will needs to be redrafted on each of these occasions. It's more of a point of ensuring that the will is taken into account the client's current and accurate financial and personal circumstances. Now, following these wise words of wisdom, I think it's a good point for me to hand over to John, who's going to look at taking you through how you can create security for your loved ones financially, and also what opportunities currently exist in the financial market. So, by way of an introduction to John, John is a chartered financial planner who is part of his own firm, Solosy Wealth Management, predominantly working with high net worth clients, both individuals and corporates. So at that point, John, if I can hand over to you to take it from there. Thank you.
Thanks, David. That's great. Morning, everyone. If we can go to the next slide, please. I thought this morning that it would be quite relevant, bearing in mind how fallible we're all feeling, to look at what we've got in place at the moment, to talk a bit about the cash holdings that we've got or not got, as the case may be, and then to put a bit of perspective in terms of what's going on within the markets themselves, to hopefully provide some degree of reassurance for those of us that have got pensions or are holding liquid investments in the stock market. And so if I start with what majority of us got in place already, whether it's us, our parents, our children, and we look at the fact that most of us will have some form of pension, and whether that's a workplace pension or an individual pension. Most of us will have some form of life assurance if we've got dependents that are reliant on us, and should the worst happen, that they need to be looked after and any debt cleared or income to support them required. And then, of course, people have employee benefits. And the first thing, which David has already highlighted, is just to make sure that you've identified who you want to receive those benefits, whether that is a payment from a life assurance or an employee benefit or your pension. Because for many of us, we took these policies out when our children were very young, or we took them out when we first started working. And the person that we named then might not be the person we want to receive them at the moment. So just worth pausing for a second and thinking, if I passed away or if something happened to me, where would I want that money to go to? And that's the first kind of decision that you should be thinking about. Once you've made that decision, you need to think about what the implication might be in terms of that money and how it might pass to that individual. What's the position of that individual? If you've got a disabled child, how would it be if they received the money directly into their estate? Could it have an impact in terms of what the government supports them with? What's the impact on estate value if the money falls directly to a person? So in a scenario that's fairly simple, if a family have a house that's worth £500,000, so husband and wife, and they've got a couple of £100,000 in cash and savings, so they've got maybe £700,000, but they've also got life assurance benefits of maybe £300,000 and a pension of £500,000. Effectively, what you've got is that in the estate at the moment, they've got a value of £700,000. £500,000 in the house and £200,000 of cash and liquid investments. Now, if the individual were to pass away and they've named their spouse as a beneficiary, effectively the life assurance plus the pension would fall into the estate, automatically putting those individuals to a value of around £1,500, so 1.5 million. Now, the implication to somebody when you're thinking in those terms is that you're automatically triggering an inheritance tax liability on the death of a second person. So when we're talking about how the money passes across, think about who should receive and whether it should go directly to an individual or whether you should use discretionary trust. And as David's already highlighted, discretionary trusts are then distributed based on the trustees, but you can ensure that the right person is getting it at the right time. The next side of things is to consider your cash holdings. Now, depending on where you are and what position you are in your life, your cash holdings will vary. Now, for those that are slightly older, you'll have children that might be going through fairly difficult periods with furloughing and uncertainty with regards to their work. You may be thinking you might have to help them out should there be kind of any future redundancies for them. So as always, it's really important that you've got that emergency pot should you need it. Then for those lucky enough to be in employment or to be in receipt of decent pensions in retirement, but not able to spend at the moment, you might be seeing a different implication as you're going forward. The implication at the moment might be that you're building up money, and you need to start thinking about what's that money for. If you're retired and you're building up money and you're building up your estate, can you think about gifting, and therefore gifting regularly from surplus income? Which means that you don't have to, you're not subject to the 7-year inheritance tax rules. If you're working, what's this money for? What can you use it for? Is it to support children? Is it to support children when they go to university? Or is it to help you in retirement? Can you get the tax benefits as you go forward? So again, just pause and think, what could you use that surplus money for that's beneficial to you? Now, I know many people like to hold large amounts of surplus cash. And whether that's within your business or whether that's as an individual, you've got to think to yourself, what are the protections and how secure is your bank at the moment? And we've seen at the moment that there's lots of kind of online technologies happening. I'm having lots of Zoom conversations with family and friends that I wouldn't have had before, where we would have got together for Sunday lunch. Well, there's now applications where you can actually open one bank account, but through that one bank account, you can access 3 or 4 different banks and spread your money so you're getting lots of different protection for the money you hold. And therefore, you're not just subject to one protected amount, you get the benefit of spreading and diversifying across banks. On top of that, you generally get a better interest rate, so you can try and make your money work harder for you. So again, just pause, think what the money's for, and think of the implication of having it in cash and what else it can be used for instead. If I can have the next slide, please. I'll move on to investments now. And for many, we hold our pensions in investments, or we hold our surplus income in investments, either because we're building up for something or because we're trying to work out how to keep the purchasing power of our money. Now, the average retail investor will go and they will decide that they want to put money in for the first time, maybe as a young couple or as somebody who's got surplus income but got no dependents. And quite often they've waited until things are feeling good within the economy. And quite often that's quite late in terms of the economic cycle. So there's an excitement about putting in and they see an immediate return. Now, quite often you can see on this kind of the roller coaster of emotion slide that's on at the moment, you can see the kind of the environment that people feel. And we find that generally some people pull their money fairly quickly as the market's dropping or when the market's near the bottom, rather than riding it out. And then they miss the next cycle, but going again 2 cycles on. And the same thing happens again. So for some people, their experience within the markets is very poor. And it's that emotional nervousness about uncertainty about losing money. If we can go to the next slide, please. So what I wanted to try and show, and this is showing the FTSE over the last 50 years. And if you look at the various kind of troughs over the last 50 years, you've had the OPEC oil crisis, you've had Black Monday in '87, you've then had the ERM crisis, you've had the dot-com bubble in the late 90s, followed by September 11th. Then, of course, 2008 and the Eurozone crisis. So across all this, effectively, we've got this kind of upward and downward trend that's following. But it's about riding those waves and that consistency of keeping the money in. If we can go to the next one, please. So in terms of people with money at the moment invested, what I wanted to show in this slide is actually what happens in a market in terms of the highs and lows. So the dark blue that you can see at the top is showing the positive discrete returns of the FTSE All-Share since 1986 to 2019. The red shows when the markets have made a loss, and the orange dots that you can see are shown the worst point in the markets over each of the years. Now, the key thing really to take from here is that there's more blue than red, and that in any given year, Some years can be particularly bad. So if you look at 1987, where it went down to minus 35%, but actually at the end of that year, it was up 8%. And similarly in 2009, after the crash, where it went to minus 21%, and at the end of that year, it was up 30%. It's trying not to be too absorbed in all the bad press that you're reading and thinking about the long term as you look at your money. If I can go to the next slide, please. And then finally, when we look at this slide, we look at the black zigzag lines, which shows the volatility, whilst the red line shows the return on the FTSE over the last 30 years. And so again, it's just trying to show that when you are investing, you've got to think medium to long term. So the key things really from what I want to get across are review who the beneficiaries of all your life assurance, employee benefits and your pensions are. Make sure they're appropriate for that person in terms of how they receive them, whether it's going to have an implication to them as an individual or to the next generation, and what the tax implications are. And secondly, when you are invested in the markets, think about when that money's for. It should always be medium to long term. So try and ride out the waves and don't react to short-term blips in the market. Thank you, David. Back to you.
Thank you very much, John. Thank you for that. I'd now like to introduce Annabelle, who is a senior associate at Harrison Clark Rickaby's, but sits within our old and vulnerable persons team. Annabelle's going to talk to us this morning, and Annabelle, over to you. Thank you.
Thank you. Thanks, David, and good morning, everyone. So as David says, I sit under the private client umbrella, but my area of particular interest is advising clients who would fall under the definition, I guess, of being vulnerable. And I think if we look at pre and post COVID times, we will probably be aware that some people are feeling far more vulnerable than usual. And so in respect to the message that we want to, or I want to give you about managing and considering how to structure your financial and welfare affairs, much of it seems very similar to the message pre-COVID, but there's definitely some changes that we've seen post-COVID, and I'll dwell on some of those in a bit more detail. So I think if you were to ask many private client lawyers about what the advice would be in order to protect themselves, for a client to protect themselves, it would be make sure your will is in place, make sure it's up to date, make sure it reflects the circumstances which you have at the moment. So, for example, if you have young children, you may want to consider making sure that your money is, as we mentioned earlier, settled onto the terms of a discretionary trust. That trust structure may remain very stable, but family life may change, and that can be guided by way of updated letters of wishes as things progress, and which might well reflect changes in circumstances that your children are experiencing. And it will serve to protect from an asset protection perspective. And also, should you have a child potentially who may be experiencing special educational needs or has other types of disability, which means that they are more dependent on local authority services on a means test basis, then by having their entitlements settled within the terms of a discretionary trust means it is protected, and their entitlement to benefits shouldn't be jeopardised, nor anything else they may be receiving on a means-tested basis. So, yeah, wills are the common message, as are powers of attorney. But I think it's really important if we look at now and what we think about how to protect our clients, and in this ever-changing social and situation that we find ourselves in, and the attack on people's health and the long-term effects of going through a period of prolonged ill health and what that might mean, I think that we can open up the definition of vulnerability even wider than what we might consider it. So it may no longer mean a child with a disability or an older person with dementia. It may well mean somebody who's dealt with an onslaught of COVID patients and is suffering very difficult and protracted period of PTSD. It may well be a family that's been through multiple bereavements, and all of those circumstances are not imagined. I think that they are quite honestly real. And our job, I think, is to put people into a position where we can give them some fairly instant solutions to current problems which may arise. The sort of difficulties which vulnerable clients who live with mental illness may experience are just simply an inability to cope with their financial affairs on a day-to-day basis for a while. Under those circumstances, we don't maybe want to consider that powers of attorney are the immediate instrument. We may look at things like ordinary powers, which would give the person the opportunity to appoint somebody to deal with something quickly and easily, and perhaps limited to their accounts or claim for benefits, or the ability to organise and sort a debt. And that this type of power would last for the period of no longer than a year unless it's renewed, and would give somebody vital breathing space to step away from having to deal with something which is impacting upon maybe their ability to cope, and allow them to focus on the important business of getting well. Likewise, the concept of dealing with multiple bereavement may just simply mean that somebody is just unable to mentally or physically cope with the concept of managing their own affairs or those of whom may be left behind, and it may just be overwhelming. And again, that type of power of attorney serves a very useful purpose to the extent that when the ink is dry on that document, it is ready for use. It requires no registration, and can be used immediately by the named attorney. There can be more than one attorney appointed under it, and as I say, it can be restricted to the types of financial situation that the individual wants it to cope with. If you are aware of powers of attorney, you may also be aware of powers of attorney for health and welfare. You may also be aware of the concept of an advance directive, perhaps formerly referred to as a living will. The power of attorney for health and welfare, once registered, gives the attorney the ability to make decisions on behalf of the person who's made it, if they are lacking capacity at that particular time. So pre-COVID, one might never imagine that the person would ever be in hospital, ventilated, and requiring long-term care on a ventilator and potentially thereafter. And so it would give the attorneys the abilities to make decisions about ongoing treatment whilst in hospital, and perhaps more importantly, until that person was a great deal better, the ability to make and organise care packages when they are out of hospital. And the same extends, of course, into perhaps what we might have termed more normal times, or what might become the new normal, in terms of making those decisions for individuals when they lack capacity to make health and welfare decisions for themselves. We as lawyers would always advocate that it's never too early to make a power of attorney, and certainly that is the case. As David said at the beginning, I'm sure the 18-year-old him, like the 18-year-old me, would have been hard pushed to have made a power of attorney given my parents any say-so over my finances or health and welfare type decisions. But I certainly have looked after clients where they've been away travelling and incidences have occurred where they've become profoundly injured and they've needed to be flown back to the United Kingdom for ongoing treatment. And they've had the foresight of mind to have powers of attorney created, which has facilitated that no end. So a lot of these documents absolutely have their place and had their place pre-COVID. They have their place now. In terms of communicating the message about wills and powers of attorney to people in these vulnerable times, we don't want to do that from a perspective where we frighten people. Getting COVID-19 doesn't mean that you're going to die of it, but it might mean that you need some additional assistance while you recover from it. And being aware and having seen a mounting death toll of up to nearly 33,000 people, certainly we as private client lawyers, or who sit under private client, I'm sure Dave would agree, is that at the early stage of this crisis, we saw a great deal of any inquiries from people wanting to have their wills reviewed and updated on that basis that you know, they were very much frightened by what should happen if I am caught by this virus and I don't survive it. But the message remains the same, you know, pre or post COVID, the importance of having a will in place, the importance of having active documents which give others the opportunity to help you in place, whatever your level of vulnerability, I think are absolutely vital. And just, I guess, also perhaps of a particular area of interest of mine, but I'm going to leave more of this to Emma to elaborate on, is that in relation to end-of-life planning and the importance of that. I mean, it is a difficult message. It's not one that we have routinely when we talk with clients. I used to be a nurse, and I think I have an element of comfort in raising difficult questions which maybe others don't have, but it is still a difficult concept for clients to engage with, understandably. But I think as much as we can encourage people to want to think about how would you wish to be treated at the end of your life, do you want to set your own ceilings of treatment for the end of your life? Or if there is to be an ongoing discussion about how end-of-life care should look, who's that going to be discussed with on an ongoing basis? So whatever document is prepared, which comes into the hands of a treating clinician, is that still relevant and fit for purpose? Does it still reflect how you would feel and perhaps what your relatives would want for you? So I think maybe from our perspective in this post-COVID times, and I think one of the things that I know that I will be encouraging clients to talk about, should they wish, will be discussing more in a more open way about planning for end of life. I mean, we all know that we hope that we never see anything like this in our lifetimes again, but it's not gone away, and we don't know when or if a second wave will strike. But we do know, and I know, that I want to be involved in arming clients with as much protection as they can possibly have to make sure that in how they ride out these times, that they're as best equipped as possible. And whilst those legal measures aren't terrifically sophisticated, they certainly lend vital help where they're needed in these sort of difficult times. And I'll be delighted to take any additional questions that you may have in relation to that. But otherwise, I think I'll pass over to Emma so she can elaborate further.
Yeah, thank you for that, Annabelle. That was really interesting, and yeah, I think it's a great opportunity to hand over to Emma. Just before we do that, though, just a reminder: if anybody does have any questions, if you want to put them in the Q&A box, and then following Emma's talk, we will get round to answering those. So, just by way of a short introduction, Emma is the CEO of St David's Hospice Care, based in South Wales, and Emma is no doubt hopefully going to pick up on some of those points that I know Annabelle has raised there, and hopefully give us some practical experiences as well. So, Emma, over to you. Thank you.
Morning everyone, and thank you David very much for inviting me this morning. Just to put into context, as Annabelle is also a nurse, so am I, so although Chief Executive of a hospice, very much coming from a patient perspective and also from a clinician's perspective. Our hospice currently is looking after over 1,000 patients in their own homes today, and we have a 15-bedded inpatient unit in Newport also, just to give you a little bit of context of the size of our hospice currently. We are seeing a great number of patients and families very, very concerned about the impacts of COVID-19, not only on their current treatment plans, but also on end-of-life care. And we would see ourselves in normal times as being experts in end-of-life care. But our skills and our knowledge are being called upon every day, not only for patients who would normally be referred to the hospice, but for those patients that have COVID-19. I think I have a couple of areas to cover, and the first one is many people may have heard about Do Not Attempt Resuscitation form. These forms are widely used in pre-COVID normal times, and I think the difficulty is for patients and families at the moment is when we're looking at discussing the appropriateness of that particular instruction to clinicians. It would normally be done over quite a period of time, and much time would be spent with patients and families explaining the reasons why this might be beneficial to them, but also reassuring them about when it would be most appropriate to instruct such a form. I think some of the things we're finding now is that perhaps patients and families, patients in particular, are feeling that those forms perhaps are being asked about or brought into the conversation much more quickly than we would normally do. Because we don't want patients to suffer unnecessarily, and we want them to make the right decisions, but we need to make sure those are really supported decisions and that the clinicians are there to support them. So it's really important for us as a hospice and those of us working in palliative care to make sure that we are supporting clinicians and patients when we feel that attempting resuscitation may not be in the best interest of that particular patient. In normal times, we deal a lot with advanced care planning. Annabelle has referred to that already. An advanced care planning document we use with patients who have capacity, and it's a voluntary process where individuals with capacity can make their wishes known for their future care. Very important pieces of documentation, and even more so important in these particular times. And then we also have some best interests decision documentation that can also be used for patients that are lacking capacity. For those patients that are lacking capacity, it's really important to discuss any decisions around treatments and care with families, and that has been difficult with the issues around families not being able to visit, for example, because of the restrictions around COVID-19 and infection control. But advanced care planning documents and DNAR documents are really vital to make sure that we are all travelling in the same direction with a patient's care. And it's really important, if those documents are in place, that we make sure that every care provider that goes to see that patient knows of those documents and knows where they are. And so particularly for those 1,000 patients that we've got in the community, it's really important that should a paramedic turn up, should an out-of-hours doctor go to attend to a patient, that they know those documents are in place. So a big part of the advanced care planning documentation is checking that everybody who needs to know knows the wishes of that particular patient. Although not legally binding, we know what the wishes are. At this time, we're supporting patients in very different ways. Many of our patients will be having ongoing treatment, radiotherapy, chemotherapy, and are really concerned about how that's going to continue in this crisis. So a lot of the calls that we're making at the moment are giving telephone or virtual support to our patients and their families to support them through what is a really frightening time for them, and how that might be impacting on their future regarding their disease process. We're also talking to patients and families about how they might want to communicate their changing views about their care with their healthcare professionals, and more importantly with their family and carers. And finally, because I know we want to have some time for questions, finally, just to touch on bereavement care. Our service has now opened the whole of our bereavement team to anybody in our area that we cover, for patients who have had, or family members, sorry, that have had patients and family members dying from COVID-19. I don't think we can overestimate how difficult this is going to be for patients and families in the future. I think patients that have died from COVID-19 have often died very rapidly, and their families haven't perhaps been able to say the goodbyes that they would normally have been able to do. The long-term effect on people's bereavement, I think, is going to be significant, and therefore specialist services like our bereavement team and other hospice bereavement teams are really going to be needed, not just in the next 6 months, but in the next 2 to 3 years, where people will have that profound impact of not being able to say goodbye, or chatting and talking, and having those last conversations that so many people hold on to, that allows them to come to terms with losing a loved one. And we're also seeing many families that have lost people who are very young. And again, the impact of the bereavement for those families is so very significant. So with not just our adult bereavement service, but also with our children's bereavement service, we hope to be able to support those families and our local communities over the next 2 to 3 years, as the full impact of this awful pandemic will be realised on our communities. So I'm grateful for having the opportunity to talk to you today, and I say if there are any questions, we'd be very happy to take them. Thank you, David, very much indeed.
Thank you for that, Emma. That's fantastic work that the charity is doing there. So yeah, well done to everybody involved. I think whilst and sort of just to follow up really on what Emma's mentioned there, and if I can bring Annabelle into this one as well, if possible, please. So really one of the questions that we've been asked is how does an advanced directive interact with a health and welfare LPA?
Right, it's a great question. I think typically the way that I would advise a client who is interested in making a power of attorney for health and welfare, and also wanted to engage in putting together an advanced directive, is making sure that one doesn't actually cancel the other out is of paramount importance. I think it's important to remember that with an advanced directive, as they sit at the moment, that we tend to prepare, we need to prepare them in accordance with the terms set out in the Mental Capacity Act, and we would also need to make sure that when we prepare the power of attorney, as such, that the client will sign in that power of attorney in what's termed option B. And for those who haven't made powers of attorney for health and welfare, the document itself allows you to either give your express and advanced authority to your attorneys to either give or refuse consent for life-sustaining treatment, or it allows you to choose to leave that decision in the hands of the treating doctors. We would encourage the client, therefore, to make sure that they have signed option B of that document, so there's nothing that can be overridden by their powers of attorney in respect of their advanced directive. And then their advanced directive would need to be, as I say, prepared in accordance with the Mental Capacity Act. It's usually submitted when we send the power of attorney for registration, and it will incorporate those ceilings of treatment whereby our client patient wouldn't want to be treated in a hospital environment. The document needs to be signed, witness dated. It needs to be made by a capable, mentally capable adult. It doesn't need to be made by somebody who's already got a pre-existing condition. We encourage the client to make sure that they've discussed it with their GP. In fact, many well-drafted advanced directives will state that it's been discussed with their GP or any other treating clinician at the relevant time, and once prepared, we would encourage the client to make sure that it is distributed to GP, hospital, etc., wherever they may end up being treated. The most important consideration is to make sure that there's a lot of living and decisions to be made before the client may get to an end of life position, and making sure that the power of attorney for health and welfare is understood by the attorneys and what they can do in terms of planning care, treatment, and what they consent for. But if that power of attorney has been properly prepared, it's been the power of attorney itself and the advance direction go for registration together, so the Office of the Public Guardian are aware that one is not cancelling the other, then I think that the document, even if it was made several years ago, we don't then have the client's wishes, but the document should be as valid at the time when it's required as if it were made more currently. It should be, as Emma says, a well-made document is one that's kept updated, but it's just really important to make sure that we don't cross over the authorities underneath them, because, it will end up cancelling out the other. I advise that they're made together.
No, thank you, Annabelle. Emma, did you want to add anything to that?
No, I think what Annabelle said encapsulates it all really. I think it's just about making sure how those legal documents also fit in with things like advanced care plans, which are not legally binding, but may have very up to date information, because somebody may well have been asked to input into an advanced care plan within the last day or so of their life, and they may change some of their wishes. So it's just important, I think, to make sure they're used in conjunction, really.
Okay. Thank you. Changing topic slightly, John, question for you, if possible, please. We've had a trustee pose us a question in connection with their current trust investments, and they've noticed a decrease in the value of the investments over the course of the past 12 months, and really just sort of querying whether or not they need to be worried about that, and if there's anything that they need to be looking at, and what should they be doing at this point in time, really.
It's a natural concern for most trustees at the moment. Bear in mind their responsibility to make sure that the funds are invested properly. At this moment, I would say the key thing really is to conduct a thorough review of the investments you hold. It's in theory, you've got a wide diversified portfolio, and within your kind of long-term objective as trustees, you've identified when this money is likely to be needed for. Ideally, if that money is for the medium to long term, then, and the money is invested in the right types of portfolios, then actually you should try and ride out what's going on at the moment and not panic. I think the key really is to review what you've got, make sure it's designed to meet the objectives that you set originally as the trustees, and if it is, then to hold with it and stick with it, providing you've got confidence in how it's being managed, and then move from there, really.
Oh, brilliant, thank you. And we've had a question through in connection with trust bank accounts as well. I know where we're opening trustee bank accounts, Annabelle's smiling, it can be a difficult one to deal with, and there are only certain providers that we found that will open those accounts, and in terms of the documents that they would typically ask for, we found that they will accept a certified copy of the will. Obviously, with the original going off to the probate registry, it's not possible to get that back. In terms of the banks that we use, I mean, there are others out there, but we use Cater Allen at the moment for a number of trust bank accounts. John, I don't know whether you're aware of anybody that offers that facility at the minute.
Yeah, Cater Allen obviously good. We also use one of the new upcomings, the Metro Bank. Again, we've got relationships with them, which means that we're able to kind of deal in a more hands-on way when helping trustees set them up. So there are some out there. Some have shown flexibility in terms of, as David's already highlighted, certified copies of wills. So yeah.
Brilliant, thank you. And Annabelle and Emma, question for the two of you now. Can solicitors see patients in hospices and hospitals at the moment?
Oh, that's a difficult one to answer. I mean, yes, solicitors can see patients in hospital. I suppose it's an element is at the discretion of ward management, but that's the general position. I think at the moment, I wouldn't presume to be allowed in to see a patient in hospital. I would hope that if somebody was gravely ill and there was an absolute need and it had been agreed with relatives beforehand, there might be some flexibility. But otherwise, I think we'd be reliant upon technology. And certainly, I think one of the things that we've noticed is that since the pandemic has been raging, we've seen a relaxation within most law firms, I think, in respect of the compliance procedures we normally have to, we're obliged to follow, and some of the rules about how to effectively sign documents. So clients who are patients in hospital are not denied the opportunity to get legal advice that they might be needing, which must be right. But I think for everybody's safety, it might be, it's probably not as straightforward, and I would imagine that there would be, quite an element of negotiation beforehand.
Emma, are there any practical examples that you can share with us in terms of patients that may have had people visit them in hospice at the moment?
Yeah, I mean, obviously I can't speak for the hospital because I don't run a hospital, and I think, within a hospital setting, they have various levels of infection control procedures depending on where the COVID patients are within that particular hospital. If I speak for the hospice, I think we've tried to be as flexible as we possibly can be with visiting within the hospice, because I feel very strongly that if we can allow relatives to see their loved ones, it makes such a difference, not only to them but also to the patient who's dying. So for me, it was really important right at the beginning of this crisis to work out a way of being flexible, if we could be, by ensuring that everybody was wearing the correct PPE. For example, if it was, if you had, which we did, if you have a young person dying with children, that mum or dad wants to see those children. And it's really important that we find ways around that. And we've been lucky that we have every room within our hospice has its own patio doors. And so we're able to bring people in through a separate entrance. And so it may well be whether somebody, it's really important to them to see their solicitor. And if that's really important to them, it's really important to us that we can deliver on that. And I think as long as you keep people safe and you're careful, I think there are ways around it. But the impact of not doing it, as opposed to the impact of trying to make things work, is so enormous. And so any decisions we've made, we've thought very carefully about the impact, not only on the safety of our staff, but on the safety of the patient and the relatives. Most importantly, the impact of making the wrong decision on a patient and family's bereavement in the future. And so if somebody needs their particular member of the clergy, for example, to come in and see them, that's really important when you're dying. And so we have to work around ensuring that we can deliver on those last wishes if we possibly can. And I know in the hospital setting they've been very innovative around trying to deliver on that. It is slightly easier for us in the hospice environment. We're not intensive care, and I say our building, because it's brand new, has lent itself to be able to deliver on being quite flexible if we possibly can, because we know that if you want to see your children or your dog or your clergy, member of the clergy, or your solicitor for that matter, that is really, really important, and so we have to try and be flexible.
Oh, brilliant, thank you. Another question that we've had in, and I'm paraphrasing slightly here. I'm one of 6 shareholders in my business, which is increasing in value. Is there anything that we need to be considering at this moment in time? And I think I'll bring John into this one in due course, but I think just for some comments from me initially, I think really with business owners, it's making sure that shareholders agreement are one in place, because disputes can happen. You may all be getting on at the moment, but what happens if something goes wrong in the future, and tying in with those shares is effectively what happens to them on death. So are the shares going to be transferred? Is there going to be a provision in the agreement that there's an automatic buyout of the shares? And if there is, where is that money going to come from? And I'll ask John to comment on sort of what options are available there in a moment. But just sort of a couple of final comments from me on that. I think looking at powers of attorney at the moment, and Annabelle touched on it earlier. So that those general ordinary powers of attorney could be key if shareholders are unwell or just out of the country and need to be able to sign documents or deal with transactions. They can be absolutely key. I think, John, if I can ask you to touch on that sort of point about buying of shares on a shareholder's death, that'd be really helpful.
Yeah, of course, David. I think it's a really valid point in terms of the points that David's brought up. The fact that if somebody does die, that's one of the shareholders, the provision is in terms of what's going to happen to that person's shares is really important. And putting something in place like a shareholder agreement with a life assurance policy that can then effectively pay out to enable the purchase of those shares, so that both the existing shareholders and the family of or the beneficiary of the person who's passed away are all in a positive kind of territory once somebody does pass away is really important. Similarly, with a growing business, in terms of where you are, you've got to look at what the key components of that business are as well, in terms of, do you have any key people within the business that if something happened to them, that the profitability of the business and the long-term growth of the business are impacted. And again, just looking at options in terms of protecting against something happening in terms of a loss of revenue from those guys as well. So there's a whole series of things that are worth reviewing and seeing whether you need to look at life assurances or other type ways of covering things that might impact your business in the future.
Yeah, thank you, John. And I think I'm just sort of conscious of the time. We said we'd try and keep this to an hour, but I think perhaps a good question to end this on really is just to get Emma's thoughts on how charitable giving benefits the hospice.
Well, we're facing unprecedented times in the hospice sector. We're one of the oldest hospices in the UK, and 75% of our nursing salaries are paid for by charitable giving. And unfortunately, as you will know, we have, well, you may or may not know, we have 38 shops, all of which are shut. They are a major source of revenue for us. Also, all our fundraising events that we hold throughout the year, we have lost hundreds of thousands of pounds. So we are now only reliant on the 28% of government funding that we actually get. So we are, at a critical time, really. We have had some government support, but I cannot emphasize enough how desperate we are in the hospice sector to receive support from people who are able to, because this could never have been predicted. And hospices are providing vital vital services on behalf of the NHS, and we're looking after thousands of patients every day who need our palliative and end-of-life care. And so it's had a major impact. And so if people are able to support us and make a charitable donation, this is the time, to do it, because it will never have such an impact as it would now.
Fantastic. No, thank you for that, Emma. And I know as a firm from my Cardiff office, we are sort of working with St David's with a view to drafting wills and sort of speaking around the legacy giving point there as well. So if we can be of any help to anybody, please don't hesitate to get in touch. Well, I think on behalf of all the panelists, thank you very much for tuning in today. I hope that's been useful. In terms of a follow-up to this webinar, we will be sending an email out to everybody with a link to access the webinar, and we're also going to produce some details in terms of the questions that have been posed to us today, just so that you've got something in writing, giving responses to those. But I think only sort of, just thank you to everybody, and if I can draw the webinar to a close at that, I think that's great. Thank you very much, everybody.